What are we going to be looking at today then? Well, let's have a look at the overview. The catalyst really for writing this course was the Police Crime Sentencing and Courts Act, which you'll all be familiar with for various reasons with the new changes to the law that have come about as a result of that. But one of the things it's done is it's added new aggravating factors under this act. So I thought it was a good time to have an update generally on assault, aggravation, sentencing to include this new aspect of the act. Secondly, I've been with us for a little while now, but I thought it was also worth taking a look at assault on an emergency service worker and the issue of sentence. That, of course, was changed under the Police Crime Sentencing and Courts Act as well. We'll talk about that a little bit, and we'll also talk about some very helpful case law. I say helpful if you're a prosecutor, more than if you're a defence advocate. But we'll answer the question, does the person have to be in the execution of their duty? Of course, the issue that was often came up in assault PC cases in the magistrates' court. We'll see if that has carried through to this new offence or whether or not there has been a change. And then we'll turn and have a look at racially or religiously aggravated actual bodily harm. We'll have a look as well at racially or religiously aggravated grievous bodily harm or indeed unlawful wounding. So Section 47, Section 20, Section 18. And then we'll also look at what evidential proof the court requires in order to find an offence is aggravated for the purposes of the Sentencing Code. Turning then to Assault on Emergency Worker Offences Act 2018. As you'll be aware, I'm sure, when the Act came into force, it increased the penalty for common assault on an emergency worker to 12 months. Okay, so of course the original sentence was one of 6 months for common assault, or indeed 6 months for an assault on a constable in the execution of his or her duty. And this offence, this new offence, statutory offence, increased sentence to 12 months. Now, of course, what that meant when it initially came into force was that this then became an either way offence. Okay, it became an either way offence instead of a summary only offence. And that meant, of course, that at the time that the magistrates' court sentencing powers for an either way, a single either way offence were, of course, 6 months imprisonment. So if they thought it was worth the maximum, if the defendant was convicted after trial, they would have to commit for sentence to the Crown Court.